If you or someone you know has been waiting months for a green card, a work permit, or an asylum decision, and your application has been frozen simply because of where you were born, then this video is for you. This week, a federal court in Boston made a landmark ruling. And it could change everything for hundreds of thousands of people stuck in immigration limbo right now. Stay with me. This is important. Welcome back to Immigration Updates Today. I am glad you are here because the news we are covering today is genuinely significant. A federal judge in Boston has issued a preliminary injunction blocking a United States Citizenship and Immigration Services policy that treated applicants from travel ban countries as a significant negative factor in immigration decisions. This ruling affects applications for asylum, green cards, work permits, and naturalization. And it is part of a much bigger legal picture that is unfolding right now across the United States. If you are from one of the 39 countries on the travel ban list, or if you know someone who is, keep watching. I am going to break this down clearly and tell you exactly what it means and what you should do next. What was happening before this ruling? Let us start from the beginning so you understand why this ruling matters so much. In December 2025, the Trump administration expanded the travel ban to include an additional 20 countries. And on January 1st, 2026, the administration expanded the pause on immigration applications to include individuals from all 39 countries listed in the expanded travel ban. That means applications for green cards, work permits, asylum, and even citizenship were essentially frozen. Not denied, just frozen, indefinitely. Estimates from immigration experts suggest that about half of all immigration applications currently at USCIS are impacted by these travel ban-linked pauses. That is an enormous number of people. The impact has been wide-ranging, from spousal sponsorships to work permits to renewals for DACA recipients from those 39 countries. And many of these people had done everything right. They filed their paperwork. They paid their fees. Some even paid for premium processing. And still, nothing moved. One person from Nigeria, living in Texas, said he graduated with an engineering master's degree and had to turn down multiple job offers because his work permit could not be processed. Stories like that were happening across the country every single day. The two court rulings this week, now here is the good news. And this week, there are actually two separate rulings worth talking about. The first came on Thursday, April 30th, 2026. United States District Judge Julia Kobik in Boston issued a preliminary injunction in a lawsuit brought by around 200 people from 20 countries, including Iran, Haiti, Venezuela, and Syria, who sued over a halt on the processing of their immigration applications. Judge Kobik determined that the practice of treating nationality as a significant negative factor likely violates the Immigration and Nationality Act's bar against nationality-based discrimination. That is a very important legal point. The Immigration and Nationality Act, a law passed by Congress, specifically restricts the government from discriminating based on nationality when it comes to immigration benefits. The judge found that what USCIS was doing likely broke that law. But the ruling went even further. Beyond the nationality labeling issue, the court also addressed the agency-wide halt on processing asylum and naturalization applications. The judge found this pause was contrary to Congress's command that the agency issue decisions on such applications and that it violated regulations governing green cards and work authorizations. In other words, the judge said USCIS does not have the right to simply refuse to do its job. As Judge Kobik stated in her ruling, there is no indication that USCIS meaningfully considered the consequences of throwing thousands of benefit applicants into indefinite limbo and perpetual uncertainty. The second ruling came earlier in the week from a federal judge in Maryland. Maryland District Judge George Russell III wrote in a 39-page ruling that the USCIS policy amounted to an unlawful, categorical, and indefinite pause on green card applications, stating that USCIS does not have discretion to decide not to adjudicate at all. Two separate courts, two separate rulings, both pointing in the same direction. What the ruling actually does and its limits now. I want to be honest with you. This ruling is very good news, but it is not a complete victory yet. Let me explain what it does and does not do. The court's order currently applies to 22 plaintiffs who showed direct harm, though the judge has asked the parties to address whether relief should extend more broadly to the remaining approximately 200 plaintiffs. So right now, the injunction directly protects the people who were named in the lawsuit and who provided declarations showing how they were harmed. The judge has invited a discussion on whether to expand that protection. The ruling does not permanently end the policy, but it blocks enforcement against covered plaintiffs while the litigation continues. Attorney Jim Hacking, a lawyer for the plaintiffs, noted that this appears to be the first national ruling to address both the significant negative factor policy and the separate processing freeze simultaneously. That is historically significant. No court had tackled both issues together before this moment. The Trump administration could appeal the ruling, and the case is ongoing. Future decisions will determine whether the injunction expands and whether higher courts uphold or narrow the limits being set. So we are not at the finish line, but we are moving in the right direction. Who is affected? Let us talk about who exactly is on this list and what they are facing. Entry into the United States is now fully restricted for nationals of 19 countries and partially restricted for nationals of 20 additional countries, bringing the total to 39 countries under the expanded travel ban, effective January 1st, 2026. Countries under the full ban include Afghanistan, Iran, Somalia, Yemen, Syria, Haiti, Sudan, Chad, Myanmar, Libya, and several others. Recently added countries under the full ban include Burkina Faso, Mali, Niger, and South Sudan. Countries under the partial ban, where some visa types like H-1B and O-1 may still be processed, include Nigeria, Senegal, Tanzania, Angola, Benin, and others. Visible impacts have included delayed naturalization, delayed green card adjudications, and holds on employment authorization document production for impacted nationals, even in cases that were otherwise approvable. Recent analysis found that family-based green card approvals fell 54% between July 2025 and January 2026, and total approvals in January 2026 were 22% lower than in January 2025. These are not small numbers. These are real people, real families, real lives on hold. What about the partial lifting of the freeze for other countries? There is one more update you need to know about. On March 30th, 2026, USCIS confirmed that it has lifted its months-long freeze on asylum adjudications for applicants who are not from travel ban countries. This was welcomed news for many, but the important caveat is this. For nationals of the 39 travel ban countries, the freeze continues, and it extends far beyond asylum to work permits, green cards, and even citizenship applications. So if your country is not on the travel ban list, your asylum case may now be moving again. But if your country is on the list, the freeze is still in effect, and you are still waiting. The court rulings this week are the most significant pushback against that freeze so far. Now let us talk about what you should actually do with this information. First, check your case status. Log into your USCIS online account and check where your application stands. If your case was frozen, look for any updates or changes this week. Things could start moving for some applicants. Second, document everything. Save every USCIS notice you have received. Save proof of your original appointments, especially if interviews or oath ceremonies were canceled. This documentation may be valuable as cases move forward. If your interview or ceremony was canceled, proof of the original appointment may be useful once processing resumes. Third, be very careful about international travel. Talk to an immigration attorney before traveling internationally. If you leave the United States during the pause, you may face re-entry issues, particularly if your country is also subject to travel restrictions. Fourth, if you have work authorization, file your renewal as early as possible. Do not wait. Gaps in work authorization can create serious complications. Fifth, consult an immigration attorney. This situation is legally complex and changing quickly. A qualified attorney can review your specific case and advise you on whether you might benefit from joining a future legal challenge or filing independently. And sixth, do not rely on secondhand information or social media rumors. Follow official updates from USCIS and trusted immigration legal organizations. This is too important to get wrong. Let me quickly summarize what we covered today. Starting in November 2025, USCIS began treating nationality as a negative factor for applicants from travel ban countries. By January 2026, that expanded to a full processing freeze for people from 39 countries, covering green cards, work permits, asylum, and naturalization. This week, two federal courts, one in Boston and one in Maryland, ruled that these policies likely violate federal immigration law. The Boston ruling was especially significant because it was the first to challenge both the nationality labeling and the processing freeze at the same time. The injunction currently protects a specific group of plaintiffs with the possibility of expanding. The government may appeal. The case is still ongoing. On March 30th, USCIS partially lifted the freeze for asylum seekers from countries not on the travel ban list. But for the 39 travel ban countries, the freeze continues, and these court rulings are the strongest legal pushback yet. If you are affected, check your case status, protect your documents, avoid international travel without legal advice, and speak to an attorney. This is a rapidly developing situation, and it is one we will keep tracking closely for you right here on this channel. If this video helped you understand what is happening, please give it a thumbs up. It helps more people find this information when they need it most. Share this video with someone you know who is waiting on an immigration application. They deserve to know about these developments. And if you have not already, subscribe to Immigration Updates today so you never miss a critical update like this one. Hit the notification bell so you are always the first to know when things change. Thank you for watching. Stay informed, stay patient, and take the right steps. We will be back with more updates very soon.